A writ of habeas corpus is a writ that requires a person under arrest to be brought before a judge or into court. The principle of habeas corpus ensures that a prisoner can be released from unlawful detention, that is, detention lacking sufficient cause or evidence. The remedy can be sought by the prisoner or by another coming to the prisoner's aid. This right originated in the English legal system, and is now available in many nations. It has historically been an important legal instrument safeguarding individual freedom against arbitrary state action. It has been extended to non-police authorities, as in the 1898 Queen's Bench case of Ex Parte Dorothy Hopkins, which has successfully been utilized more recently in India to liberate a woman from a madrasa. A writ of habeas corpus, also known as the Great Writ, is a summons with the force of a court order. It is addressed to the custodian and demands that a prisoner be taken before the court, and that the custodian present proof of authority, allowing the court to determine whether the custodian has lawful authority to detain the prisoner. If the custodian is acting beyond his authority, then the prisoner must be released. Any prisoner, or another person acting on his or her behalf, may petition the court, or a judge, for a writ of habeas corpus. One reason for the writ to be sought by a person other than the prisoner is that the detainee might be held incommunicado. Most civil law jurisdictions provide a similar remedy for those unlawfully detained, but this is not always called habeas corpus. For example, in some Spanish-speaking nations, the equivalent remedy for unlawful imprisonment is the amparo de libertad. Habeas corpus has certain limitations. It is technically only a procedural remedy. It is a guarantee against any detention that is forbidden by law, but it does not necessarily protect other rights, such as the entitlement to a fair trial. So if an imposition such as internment without trial is permitted by the law, then habeas corpus may not be a useful remedy. In some countries, the process has been temporarily or permanently suspended, in all of a government's jurisdictions or only some, because of what might be construed by some government institutions as a series of events of such relevance to the government as to warrant a suspension. In more recent times, such events may have been frequently referred to as national emergencies. The right to petition for a writ of habeas corpus has nonetheless long been celebrated as the most efficient safeguard of the liberty of the subject. The jurist Albert Venn Dicey wrote that the British Habeas Corpus Acts declare no principle and define no rights, but they are for practical purposes worth 100 constitutional articles guaranteeing individual liberty. The writ of habeas corpus is one of what are called the extraordinary, common law, or prerogative writs, which were historically issued by the English courts in the name of the monarch to control inferior courts and public authorities within the kingdom. The most common of the other such prerogative writs are quo warranto, prohibito, mandamus, procedendo, and certiorari. The due process for such petitions is not simply civil or criminal, because they incorporate the presumption of non-authority. The official who is the respondent must prove his authority to do or not do something. Failing this, the court must decide for the petitioner, who may be any person, not just an interested party. This differs from a motion in a civil process in which the movant must have standing, and bears the burden of proof. Etymology, from Latin habeas, second person singular present subjunctive active of haber, to have, to hold. And corpus, accusative singular of corpus body. In reference to more than one person, habeas corpora. Literally the phrase means you may have the body. The complete phrase habeas corpus ad subjudiendum means you may have the person to be subjected to. These are the opening words of writs in 14th century Anglo-French documents requiring a person to be brought before a court or judge, especially to determine if that person is being legally detained. Praecipimus tibi quod corpus ab. In prisona nostra sub custodia tua detentum, ad dicita, unicum die causa captionis a detentionis sui, quicumque nomine praedictus ab sensata in idem, habeas coram nobis. Ad subjudiendum a recipiendum a curia nostra dio a tunc a abidum ordinare contigerit in hac part. A hoc nullitens imitatis periculo incumbent. A habeas ibi hoc breve. We command you, that the body of A.B. in our prison under your custody detained, as it is said, together with the day and cause of his taking and detention, by whatever name the said AB may be known therein, you have at our court. To undergo and to receive that which our court shall then and there consider and order in that behalf. Hereof in no way fail, at your peril. And have you then there this writ? Examples. Victoria by the grace of God, of the United Kingdom of Great Britain and Ireland Queen, Defender of the Faith, to J.K., Keeper of our Jail of Jersey, in the island of Jersey, and to J.C. Viscount of said island, greeting. We command you that you have the body of C.C.W. detained in our prison under your custody, as it is said, together with the day and cause of his being taken and detained, by whatsoever name he may be called or known, in our court before us, at Westminster, on the 18th day of January next, to undergo and receive all and singular such matters and things which our said court shall then and there consider of in this behalf. And have there then this writ. United States of America, 2nd Judicial Circuit, Southern District of New York, SS, we command you that the body of Charles L. Craig, in your custody detained, as it is said, together with the day and cause of his caption and detention, you safely have before Honorable Martin T. Manton, United States Circuit Judge for the 2nd Judicial Circuit, within the circuit and district aforesaid, to do and receive all and singular those things which the said judge shall then and there consider of him in this behalf. And have you then and there this writ? Similarly named writs, the full name of the writ is often used to distinguish it from similar ancient writs, also named habeas corpus. These include, habeas corpus ad deliberandum a recipiendum, a writ for bringing an accused from a different county into a court in the place where a crime had been committed for purposes of trial, or more literally to return holding the body for purposes of a a deliberation and receipt of a decision. Habeas corpus ad faciendum a recipiendum, a writ of a superior court to a custodian to return with the body being held by the order of a lower court with reasons, for the purpose of a or receiving the decision of the superior court and of a ed what it ordered. Habeas corpus ad prosequendum, a writ ordering return with a prisoner for the purpose of a or prosecuting him before the court. Habeas corpus ad respondendum, a writ ordering return to allow the prisoner to answer to new proceedings before the court. Habeas corpus ad testificandum, a writ ordering return with the body of a prisoner for the purposes of a testifying. Origins in England. In the 17th century the foundations for habeas corpus were wrongly thought to have originated in Magna Carta. This charter declared that no freeman shall be taken or imprisoned, or be disseized of his freehold, or liberties, or free customs, or be outlawed, or exiled, or any otherwise destroyed. Nor will we not pass upon him, nor condemn him, but by lawful judgment of his peers, or by the law of the land. William Blackstone cites the first recorded usage of habeas corpus ad subjudiendum in 1305, during the reign of King Edward I. However, other writs were issued with the same effect as early as the reign of Emir II in the 12th century. Blackstone explained the basis of the writ, saying the king is at all times entitled to have an account, while the liberty of any of his subjects is restrained, wherever that restraint may be inflicted. The procedure for issuing a writ of habeas corpus was first codified by the Habeas Corpus Act 1679, following judicial rulings which had restricted the effectiveness of the writ. A previous law had been passed 40 years earlier to overturn a ruling that the command of the king was a sufficient answer to a petition of habeas corpus. Then, as now, the writ of habeas corpus was issued by a superior court in the name of the sovereign, and commanded the addressee to produce the prisoner before the royal courts of law. A habeas corpus petition could be made by the prisoner himself or by a third party on his behalf and, as a result of the Habeas Corpus Acts, could be made regardless of whether the court was in session, by presenting the petition to a judge. Since the 18th century the writ has also been used in cases of unlawful detention by private individuals, most famously in Somerset's case, where the black slave Somerset was ordered to be freed. In that case these famous words are said to have been uttered: "The air of England has long been too pure for a slave, and every man is free who breathes it." The Habeas Corpus Act 1816 introduced some changes and expanded the territoriality of the legislation. The privilege of habeas corpus has been suspended or restricted several times during English history, most recently during the 18th and 19th centuries. Although internment without trial has been authorized by statute since that time, for example during the two World Wars and the Troubles in Northern Ireland, the habeas corpus procedure has in modern times always technically remained available to such internees. However, as habeas corpus is only a procedural device to examine the lawfulness of a prisoner's detention, so long as the detention is in accordance with an Act of Parliament, the petition for habeas corpus is unsuccessful. Since the passage of the Human Rights Act 1998, the courts have been able to declare an Act of Parliament to be incompatible with the European Convention on Human Rights, but such a declaration of incompatibility has no legal effect unless and until it is acted upon by the government. The wording of the writ of habeas corpus implies that the prisoner is brought to the court for the legality of the imprisonment to be examined. However, rather than issuing the writ immediately and waiting for the return of the writ by the custodian, modern practice in England is for the original application to be followed by a hearing with both parties present to decide the legality of the detention, without any writ being issued. If the detention is held to be unlawful, the prisoner can usually then be released or bailed by order of the court without having to be produced before it. It is also possible for individuals held by the state to petition for judicial review, and individuals held by non-state entities to apply for an injunction. Other jurisdictions, Australia, the writ of habeas corpus is a procedural remedy as part of Australia's English law inheritance. In 2005, the Australian Parliament passed the Australian Anti-Terrorism Act 2005. Some legal experts questioned the constitutionality of the Act, due in part to limitations it placed on habeas corpus. Canada, habeas corpus rights are part of the British legal tradition inherited by Canada. The rights exist in the common law but have been enshrined in the Constitution Act 1982, under Section 10 of the Charter of Rights and Freedoms. This states that everyone has the right on arrest or detention to have the validity of the detention determined by way of habeas corpus and to be released if the detention is not lawful. Suspension of the writ in Canadian history occurred famously during the October Crisis, during which the War Measures Act was invoked by the Governor-General of Canada on the constitutional advice of Prime Minister Pierre Trudeau, who had received a request from the Quebec Cabinet. The act was also used to justify German, Slavic, and Ukrainian Canadian internment during the First World War, and the internment of German Canadians, Italian Canadians and of Japanese Canadians during the Second World War. The writ was suspended for several years following the Battle of Fort Erie during the Fenian Rising, though the suspension was only ever applied to suspects in the Thomas D'Arcy McGee assassination. The writ is available where there is no other adequate remedy. However, a superior court always has the discretion to grant the writ even in the face of an alternative remedy. Under the Criminal Code of Canada, the writ is largely unavailable if a statutory right of appeal exists, whether or not this right has been exercised. France, a fundamental human right in the 1789 Declaration of the Rights of Man drafted by Lafayette in cooperation with Thomas Jefferson, the guarantees against arbitrary detention are enshrined in the French Constitution and regulated by the Penal Code. The safeguards are equivalent to those found under the habeas corpus provisions found in Germany, the United States and several Commonwealth countries. The French system of accountability prescribes severe penalties for ministers, police officers and civil and judiciary authorities who either violate or fail to enforce the law. Article 7 of 1789 Declaration also provides that no individual may be accused, arrested, or detained except where the law so prescribes, and in accordance with the procedure it has laid down. The Constitution further states that no one may be arbitrarily detained. The judicial authority, guardian of individual liberty, ensures the observance of this principle under the conditions specified by law. Its Article 5 provides that everyone has the right to liberty and sets forth permissible circumstances under which people may be deprived of their liberty and procedural safeguards in case of detention. In particular, It states that anyone deprived of his liberty by arrest or detention shall be entitled to take proceedings by which the lawfulness of his detention shall be decided speedily by a court and his release ordered if the detention is not lawful. France and the United States played a synergistic role in the international team, led by Eleanor Roosevelt, which crafted the Universal Declaration of Human Rights. The French judge and Nobel Peace Laureate Rina Copyright-Cassin produced the first draft and argued against arbitrary detentions. Rina Copyright-Cassin and the French team subsequently championed the habeas corpus provisions enshrined in the European Convention for the Protection of Human Rights and Fundamental Freedoms. Germany has constitutional guarantees against improper detention and have been implemented in statutory law in a manner that can be considered as equivalent to writs of habeas corpus. Article 104, paragraph 1 of the German Constitution provides that deprivations of liberty may be imposed only on the basis of a specific enabling statute that also must include procedural rules. Article 104. Paragraph 2 requires that any arrested individual be brought before a judge by the end of the day following the day of the arrest. For those detained as criminal suspects, Article 104, paragraph 3 specifically requires that the judge must grant a hearing to the suspect in order to rule on the detention. Restrictions on the power of the authorities to arrest and detain individuals also emanate from Article 2 paragraph 2 of the Constitution, which guarantees liberty and requires a statutory authorization for any deprivation of liberty. In addition, several other articles of the Constitution have a bearing on the issue. The most important of these are Article 19, which generally requires a statutory basis for any infringements of the fundamental rights guaranteed by the Constitution while also guaranteeing judicial review. Article 20, paragraph 3, which guarantees the rule of law. And Article 3, which guarantees equality. In particular, a constitutional obligation to grant remedies for improper detention is required by Article 19, paragraph 4 of the Constitution, which provides as follows. Should any persona unregistered trademark's right be violated by public authority, he may have recourse to the courts. If no other jurisdiction has been established, recourse shall be to the ordinary courts. India, the Indian judiciary, in a catenary of cases, has effectively resorted to the writ of habeas corpus to secure release of a person from illegal detention. For example, the Karnataka High Court heard in October 2009 a habeas corpus petition filed by the parents of a girl who married a Muslim boy from Kannada district and was allegedly confined in a madrasa in Malappuram town. Usually, in most other jurisdictions the writ is directed at police authorities. The extension to non-state authorities has its grounds in two cases, the 1898 Queen's Bench case of Ex Parte Dorothy Hopkins, wherein the proctor of Cambridge University did detain and arrest Hopkins without his jurisdiction, and Hopkins was released. And that of Somerset v. Stewart, in which an African slave whose master had moved to London was freed by action of the writ. The Indian judiciary has dispensed with the traditional doctrine of locus standi, so that if a detained person is not in a position to file a petition, it can be moved on his behalf by any other person. The scope of habeas relief has expanded in recent times by actions of the Indian judiciary. The habeas writ was used in the Rajan case, a student victim of torture in local police custody during the nationwide emergency in India in 1976. On March 12, 2014, Subrata Roy's counsel approached the Chief Justice moving a habeas corpus petition. It was also filed by Panthers Party to protest the imprisonment of Anna Hazare, a social activist. Ireland. In the Republic of Ireland, access to a similar remedy to habeas corpus is guaranteed by Article 40.4 of the 1937 Constitution. This guarantees personal liberty to each individual and outlines a detailed procedure. It does not mention the Latin term but includes the English phrase produce the body. The Constitution provides that this procedure is not binding on the defense forces during a state of war or armed rebellion. The term habeas corpus as used in the rules of the superior courts does not refer to the constitutional procedure outlined below but to provisions still operable of the Habeas Corpus Acts. The State v. Quater, 1982, IR 188, The expression order of habeas corpus does not include an order made pursuant to Article 40, Section 4 of the Constitution. Order 8401-2, RSC, Article 40.4.2 a decree states that a prisoner, or anyone acting on his behalf, may make a complaint to the High Court of unlawful detention. The court must then investigate the matter forthwith, and may order that the defendant bring the prisoner before the court and give reasons for his detention. The court must immediately release the detainee unless it is satisfied that he is being held lawfully. The full text of the provision is as follows. Upon complaint being made by or on behalf of any person to the High Court or any judge thereof alleging that such person is being unlawfully detained, the High Court and any and every judge thereof to whom such complaint is made shall forthwith inquire into the said complaint and may order the person in whose custody such person is detained to produce the body of such person before the High Court on a named day and to certify in writing the grounds of his detention, and the High Court shall, upon the body of such person being produced before that court and after giving the person in whose custody he is detained an opportunity of justifying the detention, order the release of such person from such detention unless satisfied that he is being detained in accordance with the law. Italics added. The state inherited habeas corpus as part of the common law when it seceded from the United Kingdom in 1922, but the remedy was also guaranteed by Article 6 of the Constitution of the Irish Free State in force from 1922 to 1937. A similar provision was included when the current constitution was adopted in 1937. Since that date habeas corpus has been restricted by two constitutional amendments, the Second Amendment in 1941 and the 16th Amendment in 1996. Before the Second Amendment, an individual detained had the constitutional right to apply to any High Court judge for a writ of habeas corpus and to as many High Court judges as he wished. Since the Second Amendment, a prisoner has had only the right to apply to one judge, and, once a writ has been issued, the President of the High Court has authority to choose the judge or panel of 3 judges who will decide the case. The amendment also added a requirement that if the High Court believes someone's detention to be invalid due to the unconstitutionality of a law, it must refer the matter to the Irish Supreme Court and may only release the individual on bail in the interim. In 1965, the Supreme Court ruled in the O'Callaghan case that the provisions of the Constitution meant that an individual charged with a crime could be refused bail only if she was likely to flee or to interfere with witnesses or evidence. Since the 16th Amendment, it has been possible for a court to take into account whether a person has committed serious crimes while on bail in the past. Italy. In Italy the principle of habeas corpus is enshrined in Article 13 of the Constitution, which states, personal liberty is inviolable. No one may be detained, inspected, or searched nor otherwise subjected to any restriction of personal liberty except by order of the judiciary stating a reason and only in such cases and in such manner as provided by the law. In exceptional circumstances and under such conditions of necessity and urgency as shall conclusively be defined by the law, the police may take provisional measures that shall be referred within 48 hours to the judiciary for validation and which, in default of such validation in the following 48 hours, shall be revoked and considered null and void. Any act of physical and moral violence against a person subjected to restriction of personal liberty shall be punished. The law shall establish the maximum duration of preventive detention. Malaysia. In Malaysia, the remedy of habeas corpus is guaranteed by the federal constitution, although not by name. Article 5(2) of the Constitution of Malaysia provides that, where complaint is made to a High Court or any judge thereof that a person is being unlawfully detained, the court shall inquire into the complaint and, unless satisfied that the detention is lawful, shall order him to be produced before the court and release him. As there are several statutes, for example, the Internal Security Act 1960, that still permit detention without trial, the procedure is usually effective in such cases only if it can be shown that there was a procedural error in the way that the detention was ordered. New Zealand. In New Zealand habeas corpus may be invoked against the government or private individuals. In 2006, a child was allegedly kidnapped by his maternal grandfather after a custody dispute. The father began habeas corpus proceedings against the mother, the grandfather, the grandmother, the great-grandmother, and another person alleged to have assisted in the kidnap of the child. The mother did not present the child to the court and so was imprisoned for contempt of court. She was released when the grandfather came forward with the child in late January 2007. Pakistan. Issuance of a writ is an exercise of an extraordinary jurisdiction of the superior courts in Pakistan. A writ of habeas corpus may be issued by any high court of a province in Pakistan. Article 199 of the 1973 Constitution of the Islamic Republic of Pakistan specifically provides for the issuance of a writ of habeas corpus, empowering the courts to exercise this prerogative as subject to the Article 199 of the Constitution. A high court may, if it is satisfied that no other adequate remedy is provided by law, on the application of any person, make an order that a person in custody within the territorial jurisdiction of the court be brought before it so that the court may satisfy itself that he is not being held in custody without lawful authority or in an unlawful manner. The hallmark of extraordinary constitutional jurisdiction is to keep various functionaries of state within the ambit of their authority. Once a high court has assumed jurisdiction to adjudicate the matter before it, justiciability of the issue raised before it is beyond question, as the Supreme Court of Pakistan has stated clearly that the use of words in an unlawful manner implies that the court may examine, if a statute has allowed such detention, whether it was a colorable exercise of the power of authority. Thus, the court can examine the malafideza of the action taken. The Philippines. In the Bill of Rights of the Philippine Constitution, habeas corpus is guaranteed in terms almost identically to those used in the U.S. Constitution. In Article 3, Section 15 of the Constitution of the Philippines states that the privilege of the writ of habeas corpus shall not be suspended except in cases of invasion or rebellion when the public safety requires it. In 1971, after the Plaza Miranda bombing, the Marcos administration, under Ferdinand Marcos, suspended habeas corpus in an effort to stifle the oncoming insurgency, having blamed the Filipino Communist Party for the events of August 21. Many considered this to be a prelude to martial law. After widespread protests, however, the Marcos administration decided to reintroduce the writ. In December 2009, habeas corpus was suspended in Maguindanao as the province was placed under martial law. This occurred in response to the Maguindanao massacre. Scotland. The Parliament of Scotland passes a law to have the same effect as habeas corpus in the 18th century. This now known as the Criminal Procedure Act 1701 c6. It was originally called the Act for Preventing Wrongful Imprisonment and Against Undue Delays in Trials. It is still in force although certain parts have been repealed. Spain. In 1526 the Fuero Nuevo established a form of habeas corpus in the territory of the C+or-Oro de Vizcaya. The present Constitution of Spain states that a habeas corpus procedure shall be provided for by law to ensure the immediate handing over to the judicial authorities of any person illegally arrested. The statute which regulates the procedure is the Law of Habeas Corpus of May 24, 1984, which provides that a person imprisoned may, on his own or through a third person, allege he is imprisoned unlawfully and request to appear before a judge. The request must specify the grounds on which the detention is considered to be unlawful, which can be, for example, that the custodian holding the prisoner does not have the legal authority, that the prisoner's constitutional rights have been violated, or that he has been subjected to mistreatment. The judge may then request additional information if needed and may issue a habeas corpus order, at which point the custodian has 24 hours to bring the prisoner before the judge. United States. The United States inherited habeas corpus from the English common law. In England the writ was issued in the name of the monarch. When the original 13 American colonies declared independence, and became a republic based on popular sovereignty, any person, in the name of the people, acquired authority to initiate such writs, under the 1789 United States Declaration of the Rights of Man and Citizen. The U.S. Constitution specifically includes the habeas procedure in the suspension clause, located in Article 1, Section 9. This states that the privilege of the writ of habeas corpus shall not be suspended, unless when in cases of rebellion or invasion the public safety may require it. Section 9 is under Article 1, which states, legislative powers herein granted shall be vested in the Congress of the United States. The writ of habeas corpus ad subjudiendum is a civil, not criminal, ex parte proceeding in which a court inquires as to the legitimacy of a prisoner's custody. Typically, habeas corpus proceedings are to determine whether the court which imposed sentence on the defendant had jurisdiction and authority to do so, or whether the defendant's sentence has expired. Habeas corpus is also used as a legal avenue to challenge other types of custody such as pre-trial detention or detention by the United States Bureau of Immigration and Customs Enforcement pursuant to a deportation proceeding. Inspired by the 1776 Virginia Declaration of Rights, Jefferson, in consultation with Lafayette and James Madison, crafted the U.S. Declaration of the Rights of Man and Citizen, and played a leading role in upholding the right against unlawful detention as president, right from his first inaugural speech. Presidents Abraham Lincoln and Ulysses Grant suspended habeas corpus during the Civil War and Reconstruction for some places or types of cases. Equivalent remedies: Poland, in 1430 King Władysław II Angstrom of Poland granted the privilege of chitlenia, which proclaimed, neminem captivabimus nisi your victim. This revolutionary innovation in civil libertarianism gave Polish citizens due process-style rights that did not exist in any other European country for another 250 years. Originally, the privilege of chitlenia was restricted to the nobility, but it was extended to cover townsmen in the 1791 constitution. Importantly, social classifications in the Polish-Lithuanian Commonwealth were not as rigid as in other European countries. Townspeople and Jews were sometimes ennobled. The privilege of chitlenia provided broader coverage than many subsequently enacted habeas corpus laws because Poland unregistered trademark S nobility constituted an unusually large percentage of the country's total population, which was Euro unregistered trademark S largest. As a result, by the 16th century, it was protecting the liberty of between 500,000 and 1 million Poles. Roman Dutch law: in South Africa and other countries whose legal systems are based on Roman Dutch law, the interdictum de humane libero xiebendo is the equivalent of the writ of habeas corpus. In South Africa it has been entrenched in the Bill of Rights, which provides in Section 35(2)(d), that every detained person has the right to challenge the lawfulness of the detention in person before a court and, if the detention is unlawful, to be released. World habeas corpus: in the 1950s, American lawyer Louis Kuettner began advocating an international writ of habeas corpus to protect individual human rights. In 1952 he filed a petition for a United Nations writ of habeas corpus on behalf of William N. Otis, an American journalist jailed the previous year by the Communist government of Czechoslovakia. Alleging that Czechoslovakia had violated Otis's rights under the United Nations Charter and the Universal Declaration of Human Rights and that the United Nations General Assembly had inherent power to fashion remedies for human rights violations, the petition was filed with the United Nations Commission on Human Rights. The Commission forwarded the petition to Czechoslovakia, but no other United Nations action was taken. Otis was released in 1953. Kuettner went on to publish numerous articles and books advocating the creation of an international court of habeas corpus. See also: arbitrary arrest and detention, corpus delicti are the Latin legal term using corpus, here meaning the fact of a crime having been committed, not the body of the person being detained nor to the body of the victim. Habeas corpus petitions of Guantanamo Bay detainees, habeas corpus, by the English writer and playwright Alan Bennett. Habeas Corpus Restoration Act of 2007, habeas data, Edward Hyde, 1st Earl of Clarendon, list of legal Latin terms, Military Commissions Act of 2006, murder conviction without a body, Philippine habeas corpus cases, security of person, recursodi impero, subpoena ad testificandum, subpoena duces tecum, notes and references. Further reading: Ashurbanidal habeas corpus is a legal entitlement, a poem in absence in the palms of my hands and other poems. New York, Harlem River Press. 1996. A. H. Carpenter. Habeas Corpus in the Colonies. The American Historical Review. Volume 8, Number 1, pages 18–27. Louis Fisher. 2003. Nazi Saboteurs on Trial, A Military Tribunal and American Law. University Press of Kansas. ISBN 0-7006-1238-6. Michael Dobbs. 2004. Saboteurs, The Nazi Raid on America. Vintage. ISBN 1-4000-3042-0. Charles Doyle. 2006. Federal Habeas Corpus, A Brief Legal Overview. Congressional Research Service. Peter Irons. 1999. A People's History of the Supreme Court. Viking. ISBN 0-670-87006-4. Political context for Ex Parte Milligan explained on ppA 186–189. Helen A. Nutting. The Most Wholesome Law The Habeas Corpus Act of 1679. The American Historical Review. Volume 65, Number 3, pages 527–543. Jeffrey R. Stone. 2004. Perilous Times, Free Speech in Wartime from the Sedition Act to the War on Terrorism. Norton. ISBN 0-393-05880-8. Carey Federman. 2006. The Body and the State, Habeas Corpus and American Jurisprudence. SUNY ISBN 0-7914-6703-1. Eric M. Friedman. 2001. Habeas Corpus, Rethinking the Great Writ of Liberty ISBN 0-8147-2717-4, Lisa M. Getty and Nathan James. 2006. Federal Habeas Corpus Relief, Background, Legislation, and Issues. Congressional Research Service. Donald E. Wilkes, Jr., The Georgia Death Penalty Habeas Corpus Reform Act of 1995 and Habeas Corpus, The Great Writ Hit and Habeas Corpus Incorporated and Habeas Corpus in Baseball and the Writ of Habeas Corpus in Georgia and Writ of Habeas Corpus, from the New Georgia Encyclopedia. Robert S. Walker Ph.D., The Constitutional and Legal Development of Habeas Corpus, Volume 57, No. 9, Arts and Sciences Studies, Oklahoma State University. Library of Congress Catalog, H31.053, No. 3. Robert Sells Walker Ph.D., Habeas Corpus, Writ of Liberty, English and American Origins and Development Library of Congress Control No. 200690611, ISBN 1-4196-4478-5, 2, BarristerMagazine.com, InMaterLaw.org, LegLaw.com, Petition for Habeas Corpus April 16, 1843 from Texas Tides, This American Life, 331 Habeas Schmabeas 2007, Find Habeas.